Today's topic is implementing the Connecticut Paid Leave Act and the Connecticut Family and Medical Leave Act to make sure that people understand how paid leave applies to your business and to provide tools for HR professionals. Just a few housekeeping tips, please. If you have questions, we will leave time at the end for me to review your questions. Please use the Q&A function in the Zoom to submit your questions. Please do not put your questions in the chat feature. If they're in the chat feature, we lose them. If they're in the Q&A feature, we can keep track of them during the webinar and after. We will make the slide deck and the video recording of this webinar available. The way to access the slide deck and the recording is to go back to ctpleave.org, click on the calendar of events, and click on the day. Once you get to that day, you'll see this title, and these documents will be attached to that screen. All right, we're just going to get started. My name is Erin Choquette. I'm here with Andrea Barton-Reeves. Andrea is the CEO of the Paid Family Medical Leave Authority, and has been our fearless leader as we've worked to try to get this program up and running in very little time in a pandemic. So really appreciate Andrea's leadership and assistance in this webinar. And I am the General Counsel of the Paid Leave Authority. I've been an attorney for over 20 years, handling mostly management side work. And prior to coming to the authority, I worked at the Department of Administrative Services for over 14 years. So we're going to focus more about the things you want to know and less about us. So let's talk about the agenda. First, we're going to have a quick summary of the paid leave program, and then we're going to dive into understanding the two primary laws, FMLA and Connecticut Paid Leave. So understanding what they provide, and then we'll talk about the implementation of the Paid Leave Act and FMLA, and share some resources for you. As I mentioned, if you have questions, please put them in the Q&A and we will respond to them. All right, let's just talk about the Connecticut Paid Leave Authority. We're a quasi-public agency which was created by statute with the goal of providing employees with ways to access income replacement benefits if they need to take time away from work, either because they're sick or to care for a family member. We want people to be able to actually access and take the time they need without worrying about the consequences of lost income. But equally important, we want to make sure that employers, administrators, healthcare providers, all of the people who play a role in this process understand what their roles and responsibilities are, and to make sure that they have the support they need. So at the authority, we have several responsibilities, including outreach and engagement. So we really take the responsibility of providing education and resources to employees and employers very seriously, which is why we have these webinars, why we have a website that's just chock full of helpful information and deliverables, documents you can use. We actually had to get this authority up and running because it was brand new. So we've been working very hard to establish the policies and procedures and staff that are needed to actually get the authority up and running and run the program. By statute, the contribution rate can be no greater than 0.5%. But in the future, if the trust fund remains healthy, we may have the ability to reduce that contribution rate. So that's under our authority. But really right now we're focused on receiving those contributions. There is an opportunity for employers to fulfill their obligations under the Connecticut Paid Leave Act by offering their employees a private plan that offers the same or better benefits as the authority's program. If an employer wants to do that, they have to complete an application and submit it to us, and then we will audit those private plans going forward to make sure that the employees are getting the benefits that they're told to get. And we will be administering claims for paid leave benefits. As we will discuss, benefits will become available in just a couple months on January 1st, and we're actually planning to open the doors to receiving claims in December so we can get a jump start. So we've been very busy since we were created. Just about a year ago, our website went live. Employers began registering with the authority in November of 2020. We wanted them to register, get sort of set up so that when they had to start remitting the employee contributions in January, they were ready to go. And we've been receiving contributions since January. We've been reviewing applications for private plans since February, and those are ongoing. As you probably know, the contributions are owed to the authority every quarter. So they have to be submitted at the end of the quarter, but we give employers a 30-day grace period. The quarter ends tomorrow, but employers will have the month of October to get those contributions into us. And as we mentioned in December, we're going to allow people to start submitting claims for benefits, but benefits won't actually be paid until January of 2022. Threshold question is who's even covered by this law? And frankly, who's covered by Connecticut Paid Leave Act and who's covered by Connecticut FMLA are very similar. So we're going to cover both at the same time. Who is covered? Almost everybody. If you are an employer who has one or more employees working in Connecticut, you are considered a covered employer, and your employees are covered workers. This includes nonprofits, private sector employers with unionized workforces. Even if you don't pay into unemployment insurance for some reason, you are covered by Connecticut Paid Leave. We have the ability for sole proprietors and other self-employed individuals to choose to opt in. They're not mandated, but they have the ability to opt in if they want to. But if they opt in, they have to stay in the plan for at least 3 years. There are some entities that are excluded from coverage under these statutes. And therefore, their employees do not remit contributions and will not be able to receive benefits. Excluded employers include the federal government, because we can't tell them what to do, the state of Connecticut, except as to our covered public employees, municipalities and local or regional boards of education, except as to covered public employees, and non-public elementary and secondary schools are all listed as excluded employers in our statute. There are other entities that are excluded as a result of other laws. For example, railroad workers are subject to federal laws which provide for their sick leave and other benefits, so they don't participate in our program. Similarly, if you're an employee who's works for the government of another state, state of Connecticut does not have authority over you in this regard, similar to employees of sovereign nations. So the Mashantucket and Mohegan tribes are not covered employers here. There are two tweaky little things that don't come up very often, but if you are an employee who's engaged in interstate commerce, for example, a long distance truck driver, who works in Connecticut but lives in another state, you don't pay income tax in Connecticut. So those employees also would not be subject to this, the paid leave requirement. Similarly, spouses of active duty military members who are currently living in Connecticut, but because that's where their spouse was deployed, but they actually have opted to continue paying taxes in their home state, are treated as citizens of that home state, and they would not be part of this program. So from an HR perspective, those are the two tweaky little ones you want to pay attention to, because you could have people on your staff who fit into those categories, even though the majority of your staff are covered workers. As I mentioned, covered public employees are in a slightly different category. If you're a covered public employee, you participate in the program, you contribute, and you could apply for benefits. The non-unionized employees of the state of Connecticut are by statute covered, so managers, appointed officials, elected officials, judges, and the like. Unionized employees of the state are only covered if they collectively bargain to be included. And for employees of municipalities and local or regional boards of education, they are only covered if their unionized employees collectively bargain to be included. If that happens, the union and non-union employees are considered to be covered public employees. So if you work for a municipality, you're not covered by this program unless you've got this collective bargaining agreement to become part of the program. So as I said, the first thing that we've been doing is collecting contributions. Those contributions became due, or first became due as of January 1st, 2021. The employee contributes the money to fund the authority and the trust fund. It's all employee funded, no employer money goes into it. The employee contributes 1/2 of 1% of their wages, and we're calculating the wages the same way you calculate employees' wages for FICA. And the reason we use that FICA number is because the contributions are capped at the Social Security contribution limit. So the employee is the one who has to put up the money, but the employer handles the paychecks. So they're responsible for taking the deductions and remitting those contributions with some minimal wage information to the authority on a quarterly basis. We receive that money in, validate the information, and the money is immediately deposited into a paid leave trust. The trust is administered by the Office of the State Treasurer, but it's not considered state money. It's kept apart, it's separate, and can only be used to fund the benefits and the administration of the program. It cannot be used for any other purposes. Okay, let's talk about what FMLA is and what is CTPL, or Connecticut Paid Leave. FMLA is obviously initials. You hear them being thrown around a lot. And the letters stand for Family and Medical Leave Act. When we talk about FMLA, we want to be very specific because there's actually two different FMLAs. There is a federal FMLA and a Connecticut FMLA. Both of these laws allow eligible employees to take job-protected time away from work. And both laws says that that time away from work is unpaid, but that the employer may adopt policies to provide their employees with income replacement during the leave. So that could take the form of just continuing the employee on their regular pay. Some employers do that. You're out, we'll just keep paying you. It's lovely. Most employers, however, have some sort of paid time off policy where employees have to use their earned accruals, their sick time, their vacation time, or other PTO when they're out on leave. So Connecticut FMLA, federal FMLA. The thing to know is that Connecticut FMLA is going to change very significantly as of January of 2022. The federal FMLA is not changing, at least not yet. So what are these changes? Well, who it applies to and what you get are the big changes here, right? So right now, Connecticut FMLA only applies to employers with 75 or more employees. So if you're a smaller company, you've never dealt with Connecticut FMLA. But starting in January, it will apply to employers with 1 or more employees. The other big change is who's eligible for job-protected leave. Up till now, the employee would have to have worked for the employer for at least 12 months and have worked at least 1,000 hours in the 12 months immediately preceding the leave. That goes away in January. There will no longer be an hours worked requirement, and employees will be able to access job-protected leave after working for you for 3 months. The amount of leave is changing too. Right now, it's a 16-week leave in a 24-month period with the ability to take 26 weeks of leave for something called military caregiver leave. But in January, it's going to change, and the entitlement will be 12 weeks in a 12-month period. You'll still have that 26 weeks for a military caregiver, but there's also an additional 2 weeks of leave that may be available for a worker who's experiencing incapacitation during pregnancy. Finally, as I mentioned, both federal and Connecticut FMLA have always said that the employer can adopt policies regarding use of PTO. And frankly, there was nothing to prevent an employer from saying that the employee had to exhaust all their PTO if they were out on leave. But in January, Connecticut FMLA says you can still require your employees to use their accrued time off, but you can't make them exhaust it. You have to allow them to hold on to at least 2 weeks of accrued PTO. So we've talked about FMLA. What is CTPL? Well, we use CTPL to refer to Connecticut Paid Leave. There's the statute, the Connecticut Paid Leave Act, the program, and the authority. The Connecticut Paid Leave Act is a Connecticut law that creates a source of income replacement benefits for employees who can't work for certain reasons either their own illness or family member's illness or the like. It does not provide for job protected leave. You sometimes hear this as PFML or paid family medical leave. We try not to use those letters because we think it creates confusion between FMLA and CTPL. So we really focus on calling it CTPL or CT paid leave. So job protected leave under FMLA, income replacement under CTPL for certain reasons. What are those reasons? Well, the first is you're sick, you're an employee and you need to receive treatment or recover from your own serious health condition. The definition of serious health condition includes pregnancy as well as serving as an organ or bone marrow donor. You could also take leave or receive benefits if you need time to care for a family member who has a serious health condition, which we call caregiver leave. You can also take it to, and I apologize for these pop-ups, I thought they got muted. You can also take leave to bond with a newborn or a newly placed adopted or foster child, or to deal with some of the pre-placement activities associated with adoption or foster care. And then there's military caregiver leave, which I've already mentioned. That's leave to care for a family member who's been injured on active duty in the military. There's another military-related leave called qualifying exigency leave. That is leave taken by an employee who has a parent, spouse, or child who's being deployed overseas. And so your employee is not in the military, but their parent, spouse, or child is, and your employee needs time off from work to address specific issues associated with that deployment. Finally, there's a separate law in Connecticut called the Family Violence Leave Act, which allows employees to take time off from work, up to 12 unpaid days, to address specific issues associated with directly experiencing family violence. And an employee can receive income replacement for those 12 days. As I mentioned, caregiver leave is one of the types of leave where you can take leave to care for a family member who's sick, and you can receive paid leave benefits. Federal FMLA allows you to take caregiver leave for your parent, spouse, or child who is under the age of 18 or is 18 and over, who has a serious health condition, who also has a disability which prevents them from engaging in 3 or more activities of daily living. So it's a very heightened standard for federal FMLA. Under Connecticut FMLA, come January, the definition of caregiver leave is much broader. It will still be available to take leave for your parent or spouse, but now you will be able to take leave to care for your son or daughter of any age. They don't have to show that they have a disability which prevents them from engaging in life activities. And you can also take caregiver leave to care for your sibling or your grandparent or your grandchild. In addition to these other family relationships, we have a new definition of family in Connecticut, which includes an individual related to the employee by blood or affinity, whose close association is the equivalent of these other family relationships. So what does that mean? Well, it's really intended to recognize that families come in all shapes and sizes, and there may not always be a blood relationship or a legal relationship. So we really are looking at what is the factual experience? How is this person equivalent to a parent, spouse, sibling, grandparent? It's going to be fact specific. So when an employee comes to you and says, I need to take leave to care for this person, they have to explain how this person is the equivalent of a parent, spouse, sibling, grandparent. It could be their aunt or uncle for whom the employee provides care, and is going to be the one taking care of them while they're sick, but has also been in a very close relationship, with more like what you would see with a parent or a grandparent. It could be your unmarried significant other. Connecticut doesn't recognize common law marriages, so that's never been a legal relationship in Connecticut. But if you're Goldie Hawn and Kurt Russell and you've been together for 40-something years, that's the equivalent of a spouse, right? And so they would be able to take leave to care for each other. Quick summary, this is just really for reference in the future. If you're an employer with 50 or more employees, you're subject to FMLA. If you're an employer with 1 or more employees, you will be subject to Connecticut FMLA and to Connecticut paid leave. So if you work for one of those employers, you have 3 different entitlements with 3 different eligibility standards. For federal FMLA, you have to show that you were working at least 12 months and you worked for at least 1,250 hours in the 12 months immediately preceding leave. But as of January for Connecticut FMLA, you just have to show you worked for the employer for at least 3 months. For Connecticut paid leave, on the other hand, we don't really look at how long you've been working for a particular employer. We look at how much you've earned from 1 or more employers when we look at the first 4 of the 5 most recently completed quarters. You have to have earned at least $2,325. And you also have to either be currently working in Connecticut, or if you're currently unemployed, you have to show that you had been working in Connecticut at some point in the past 12 weeks. Or you could be a sole proprietor or independent contractor who lives in Connecticut who's had enrolled in the plan. And then just another quick summary in terms of the entitlements. The leave is basically 12 weeks in a 12-month period, right? But for federal and Connecticut FMLA, you can get 26 weeks for military caregiver. We've got those 12 extra days for family violence leave in Connecticut and the 2 extra weeks for leave for incapacitation during pregnancy. And you can get income replacement benefits for basically 12 weeks in a 12-month period, with the caveat that 12 days out of those 12 weeks could be used for family violence if need be, and the 2 extra weeks for incapacity during pregnancy. All right. That sort of lays the groundwork for what the entitlements are. Let's talk about how we'll actually implement these new laws. First, let's talk about Connecticut paid leave. Connecticut paid leave is really in 2 parts. There's the contributions, which we've been doing. As we've talked about, the employee contributes the 0.5%. The employer has to register with us, deduct the funds, and remit them to us. We will be receiving and reconciling those funds. We process any overpayments or underpayments. And up to now, we haven't imposed any penalties, but next year we will be imposing penalties for non-compliance. Because this has been a sort of growing year and everyone's been learning about it, the Connecticut Department of Labor has the authority to approve payroll deductions that are not set forth in statute. And they've used that authority to allow employers to make, to take catch-up contributions. Right now, that sort of general authority to take extra money out of your employee's paycheck because you didn't start taking the contributions in January is going to expire tomorrow. So hopefully you had been able to take advantage of that. Then the other half of our program is the claims. So the employee is responsible for applying to us for benefits. It's the employee's responsibility to submit the application. They will do so by creating an account with us, or they can contact the third-party administrator we've contracted with, AFLAC, by phone and start there, but eventually we'll be creating a CTPL account. They have to provide supporting documentation to justify the need, and they have to provide us with information about their absences, so we're only providing income replacement for absences, and about any other sources of income that they receive. They are required by statute to notify the employer that they're applying for CTPL benefits. The employer is going to be responsible for completing and submitting an employment verification form. The employee will give you that form, and then we ask you, the employer, to fill it out and send it back to us. We may need you to validate absences and other sources of income. And we need you to let your employees know what your policies are. Are you going to require them to use your PTO? Do you have short-term disability insurance? And as always, with all these laws, there's an obligation to not discriminate against an employee who's utilizing these benefits. The CTP Leave Authority, with our partner, AFLAC, will process the claims, determine eligibility, review the documentation, calculate and pay the benefits, monitor the claims. If we deny a claim, employees have an opportunity to request reconsideration. If there's a fraud issue, we will be investigating that and imposing penalties. The Connecticut Department of Labor is limited in its role with the Connecticut Paid Leave Act and to hearing appeals relating to denials of claims. So if we deny a claim, employee requests reconsideration, we say, nope, you're still denied. The employee can go to DOL for an appeal. Similarly, if we impose a penalty on somebody for fraud or something, they can appeal that to the DOL. So what does this look like? Well, the worker submits the claim. They can call AFLAC, they can go to ctpleave.org and connect through that way. We have on our website a prepare to submit claim information already available. There's checklists, there's documentation, so it's all there. And the employee will actually also get a welcome packet from AFLAC that provides them with all the information they need. But the employee is going to have to tell us the reason, how much time they're going to be out, what kind of absence, is it going to be a block leave or intermittent, and they have to tell us if they have other jobs or other sources of income. AFLAC will determine the eligibility, that 2325. We've got access to DOL data, but we may also request other documentation like W-2s or pay stubs if necessary. And we'll validate that they work for a covered employer. If the employee is not eligible, we'll notify the employee right away. If they are eligible, we'll say, okay, now you need to justify the reason for leave. So provide us with a medical certification or other documentation. When we receive that information from the employee, AFLAC will make the determination about whether the claim is approved. If there's missing documentation, we'll give the employee time to cure that. And if it's denied, we'll notify the employee, notify them of their rights to reconsideration and appeal. But if it's approved, we will go ahead and calculate the benefits using the information we get from DOL as well as other sources like the employment verification form. And we'll calculate the weekly benefits. Those benefits will be issued either by electronic transfer or through a stored value card or a debit card. Basically, we plan to issue benefits every Tuesday. It's really a week and a half in arrears. So, for example, for the benefits for the week of January 2nd through January 8th will be issued on Tuesday the 18th. So a week and a half after the first week ends. We need that extra time to validate the employee's identity, make sure we don't have identity theft, to validate the offsets and other income, and make sure that the calculations are correct. Employees are required to notify us of any changes. If they need additional time, if they go back to work earlier, if it's intermittent leave, they need to let us know when they're actually taking the leave. Benefits are set forth by statute. It's 95% of the covered weekly earnings up to 40 times the Connecticut minimum wage. If someone earns more than 40 times the Connecticut minimum wage, they'll get that 95% up to 40 times, plus 60% of the difference between how much they earn and Connecticut minimum wage times 40. However, in all instances, the total benefit is capped at 60 times the Connecticut minimum wage. So if someone is earning the minimum wage and not having any offsets, they would receive just under $500 in weekly benefits from the authority. Excuse me. We had a lot of questions about the intersection between employer-provided PTO and CTPL leave benefits. Under our statute, the employee can receive benefits from both the authority and their employer at the same time, as long as the total amount does not exceed 100%. And as we've discussed, CTFMLA says the employer can require an employee to use paid time off, but they can't make them exhaust it. So what does this mean? Well, if the worker doesn't get any PTO from their employer, then the first date of leave will also be the first date that they start receiving benefits, and they'll just get benefits for that full period. On the other hand, if the worker works for an employer where they do get PTO and they have enough PTO to cover the full amount of leave, then they'll use that employer PTO if the employer requires them to do so. And they may not touch their CTPL entitlements at all for this particular leave. Or you could have a situation where they have enough PTO to cover a little bit of the leave, but not the full amount. So say they work for an employer and they have 3 weeks of sick leave and 2 weeks of vacation time, and they're going to be out for 8 weeks. Well, the employer can say, we need you to use your 3 weeks of sick leave. You'll hold your 2 weeks of vacation in reserve, and you'll start receiving PTL as soon as, or CTPL, as soon as your sick leave is exhausted. And then some employers say, well, we don't ever provide full amount. We'll provide 60% of their salary while they're out on leave. well, then we'll just add the 60% of the salary to the benefits that we provide using the statutory calculation, and the employee will receive both. If, however, the total amount exceeds 100% of the pay, we will reduce the benefits. So we're telling workers, if they're trying to figure out what they're going to get, they need to know first what their employer's policies are. Is the employer going to require them or permit them to use their paid time off? And are there any rules? Can you only use sick time for your own serious health condition, but not for caregiver? And they need to know if you offer short-term disability and what that policy says. Many short-term disability policies say that they are the payer of last resort, so the employee would have to use the employer-provided PTO and the state benefits before they could access the short-term disability benefits. It all depends on what the policy says. So that's PTL, CTPL. Let's talk about FMLA. Unlike CTPL, where the employer's benefit responsibilities were really just filling out some forms, with FMLA, the employer has a lot of responsibilities. So let's start from the top. The employee has to tell you that they need time off from work, and they have to complete whatever documentation you, the employer, require. And they have to comply with your policies, which means you have to set up some policies. You need to have a policy about how to apply for FMLA and what the rules are about PTO. There is a there is an FMLA poster that's available from CTDOL that you are supposed to post. Technically, there's one for federal FMLA as well. So your employee applies to you. You have to process that leave request and monitor the usage. And because it's job protected leave, you have to return them to work at the end of the leave. And of course, refrain from discriminating or retaliating against employees who use this benefit. CTPL Leave Authority actually has no official responsibilities relating to FMLA, but it's really hard to train people about CTPL leave without talking about FMLA. So that's why we talk about it in our training and our materials. The agency with authority over FMLA is the Connecticut Department of Labor. They are working on revised regulations to update for the new changes to FMLA and guidances for workers and employers about FMLA. And they also will investigate complaints submitted relating to denial of FMLA or retaliation or discrimination claims. Let's talk about the process. The worker tells you, the employer, they need time off from work for a reason that sounds like one of those FMLA reasons I discussed, but they don't need to say FMLA. They may not know that it's FMLA, so you as the employer need to pay attention to what they're asking for. Be like, oh yeah, time off to care for mom when she's sick, sounds like FMLA. And you have to provide them with that information. The employee is supposed to notify you at least 30 days in advance if the need for leave is foreseeable, or as soon as practicable if it's not foreseeable. As the employer, you have to decide if they're eligible, looking at the requirements of CTFMLA. So have they worked for you for 3 months? And you need to notify the worker if they need to provide you with any additional documents. You have 5 business days from learning about the need for leave to determine their eligibility and providing your employee with something called a Notice of Rights and Responsibilities. And Connecticut DOL is actually drafting a form that you can use for that. This is not leave approval. This is just, yep, it's a possibility that you might get leave, and this is what you need to do so we can make that decision. The employee needs to provide you with documentation, med certs, adoption documents. It depends on the reason for leave. You have to give them at least 15 calendar days, and if they tell you that they're having trouble getting the documentation together, you should really give them additional time. Once you get those documents, you have 5 business days to review them and approve, deny, or tell the employee if they need to give you more information. So you notify the worker that it's approved. You tell them if they have to use their PTO. You tell them what they have to do for reporting in, whether they have to have a fitness for duty before they come back. If you deny the leave, you have to tell them why. And if the documentation is insufficient, you have to tell them that and give them at least 7 days to try and cure the problem. You also need to consider if they're eligible for other benefits, which we'll talk about in a moment. If it's a foreseeable leave and everything's happened ahead of time, you could be all set, and then the employee is working away until they go into labor. So they have to tell you, okay, yep, I'm in labor, I'm not coming in. This is FMLA. Or they might have intermittent leave. So they are out several times over the same leave reason. So when they call out, they have to say, yep, this is my FMLA reason. They can't just say, I'm calling sick. The whole idea behind FMLA is that it's job protected. So the employee has the right to return to their job when they come back from leave. Same job, same terms and conditions. You can't take a first shift worker and move them to third shift. You can't require them to be 100% fit for duty or totally recovered. You have to let them back to work when the doctor says they're capable of returning with or without reasonable accommodations. So you have to think about whether there are any rights the employee might have under the Americans with Disabilities Act or the Connecticut Fair Employment Practices Act, both of which provide for the right to reasonable accommodations if you have a disability. This is not easy. We get that. Making sure that you know when your employees are out, tracking their absences, enforcing your attendance policies. That's a lot of work. We get that. But we can tell you that if you have strong attendance policies and you enforce it, it makes managing the FMLA a whole lot easier. And you might need to make sure that your supervisors tell whoever is managing the absences when the employee is out. It's no good to have the supervisor know, but not tell the person who's trying to track the leave. Med-certs are the most important thing for your own condition or caregiver leave. Get good ones. Don't accept incomplete or insufficient med-certs. Workers who take intermittent leave may be out for frequent absences, and they may not know until they have a flare-up that they're going to be out. They have a job protected right to take those leaves. So you just need to kind of understand expectations for you and for the employee. If you have employees who work fluctuating work weeks, there are specific rules about calculating what their work week is, because that goes into their entitlements. And as you mentioned, you have to think about the other laws, FMLA, federal FMLA, ADA, CFIPA. There are all these entitlements you need to think about. One thing to know, this is important for every employer to pay attention to. It is the employer's right and responsibility to designate time that qualifies under FMLA as FMLA leave. Even if the worker doesn't ask it, even if the worker says, no, I don't want to tap into my FMLA. Let me just use my sick time for this. If you're concerned about employees taking more than 12 weeks in a 12-month period off of work, the way you manage that is to make sure that you know when it's FMLA and you designate it so you can track the time. And this helps the employee because it makes sure that they know what their entitlements are and make sure that they have that job protection. This is just a summary, just to make sure we talked about everything. Pregnancy Disability Act is one I haven't talked about. If you have an employee who's pregnant, leave may be a reasonable accommodation to that employee, so you have to think about that. Also note that if an employee is out on workers' compensation, they cannot receive CTPL leave benefits. It's a complete bar. Similarly, individuals who are receiving unemployment can't get CTPL benefits. We've given you a lot of information in a very short amount of time. And I do want to check out those Q&As. So let me just tell you to go to ctpleave.org and check out the information we have available. We have posters, we have cards, we have a toolkit, we have mailers, we have all sorts of things for you as the employer and for you to share with your employees. As I mentioned, there's new content that talks about getting ready for claims. We have a small business toolkit, an HR toolkit, newsletters, videos. So check it out. If you have a question and you can't find the answer on our website or through the videos, you can submit a question to us through our Contact Us button. So you go to ctpleave.org, you click on Contact Us, you submit your question, you will get an email notifying you that the questions come in, and you'll get a response back. If you tell us you want a phone call back, our team will call. If you are okay with email, we'll email, and that way we can provide responses to your questions. Check us out on YouTube. That's the other thing. I told you we had videos. If you go to the CTPL Leave channel on YouTube, you will be able to find those. All right, let me stop sharing my screen and let's see what kinds of questions have come in while I was talking. Okay, first question. I have an employee with an ill parent who's going to be asking for leave in January to care for him. The parent has a spouse and he has 2 siblings. Does he qualify, and what can I ask for if I'm the employer? Great question. The employee doesn't have to be the only one available to work or to care for the family member in order to have eligibility for the time off. That's kind of immaterial. You could have 2 siblings or 7 siblings. If they need to take the time off, and they're eligible, they get to take the time off. So you would be asking for, from the FMLA perspective, is verifying that they're eligible. So the 3 months for Connecticut FMLA, the 12 months for 1250 hours for federal. And for proof, you would most likely be asking for a caregiver med cert. We will be posting our forms on our website soon. We know DOL is also working on forms, and the federal DOL has forms. So there's a bunch of opportunities for you to find samples. But the caregiver med cert is something that you give to your employee to have the parent's doctor complete. And that would indicate enough information to show that the parent has a serious health condition and the employee needs to take some time off to care for them. Another interesting question. We have an employee who works remotely. They live in another state. Are they covered? Well, the answer to that is the classic lawyer answer of it depends. If you report that employee as a Connecticut employee and you pay Connecticut payroll taxes and Connecticut unemployment taxes for that employee, then they're working in Connecticut as far as we're concerned. On the other hand, if they're 100% in Maryland and you pay taxes in Maryland, then they're subject to Maryland's laws and not to Connecticut. Oh, so we have a question here. The DOL has posted on their website some rules for how to manage the fact that up until January, the CTFMLA entitlement was 16 weeks in a 2-year period, and now it's going to be 12 weeks in a 12-month period. So what do? The goal is to make sure that people don't get 28 weeks in a 2-year period. And so what DOL has said is, if you've got somebody who's taking leave in CTFMLA leave in 2022, you can look back in 2021 to see if they took any leave to make sure that they don't get more than 12 weeks in 2022. It's sort of long. There are lots of examples that they offer. So honestly, I think sitting down and kind of reading it quietly a few times over and kind of maybe plugging in those examples may be helpful. And if you still have trouble, you can always reach out to CTDOL for advice. We got a great question about in-laws. Are in-laws covered? So under Connecticut FMLA and also for CTPL, we do consider in-laws as a parent, sibling, child, grandparent. So in-laws are covered in that relationship. The only kind of funky little thing is that the statute excludes sons and daughters-in-law for qualifying exigency leave. So that if your son-in-law has been deployed overseas, you can't take qualifying exigency leave for that. But for every other type of event, you could take leave to care for your in-laws. So there's a question about CTPL and short-term disability. Can you receive it simultaneously? As far as the CTPL leave law is concerned, yes, but you do have to look at the terms of your own insurance policy to see if the insurance policy says you have to use CTPL or employer-provided benefits first. So really, it's a question about what your policy says. But if the policy allows it to be received simultaneously, then the question is, how do we make sure that they don't get more than 100%? And so we will, in that employment verification form, we do ask for specific information so we can make that decision on a case-by-case basis. Oh, I'm sorry. So we've got someone who works for the state. The state has if you are an employee of the state of Connecticut, there is an additional leave entitlement, which we call CBAC, supplemental leave. It is not in opposition to Connecticut FMLA, it is in addition to. So there's nothing, if you're an employee of the state, you still have access to CBAC supplemental leave. as well as leave under Connecticut FMLA. However, you may not have access to income replacement benefits under Connecticut Paid Leave Act. And that's because of that definition of covered public employee I mentioned at the beginning. If you're a non-union employee of the state, you have access to Connecticut Paid Leave income replacement benefits. If you're a unionized employee of the state, you are not a participating employee, you haven't been contributing, and you would not get benefits from the authority unless and until your collective bargaining agent bargains for it. So, is the authority drafting policies that employers may use to meet their responsibilities? We do have a lot of information available that can be used by employers, but we can't tell employers, for example, if you are going to require your employees to use their PTO. I mean, we can tell you that requiring your employees to use their PTO will help minimize stacking, and so kind of make sure that your employees are using all their entitlements simultaneously instead of layering them out one by one. But that's really your decision. So we're providing as much information as we can, and we are providing a lot of documentation, and we will continue to do so. We have a small business sort of outreach program that we're developing, so we will do as much as we can, but we can't exactly tell you what to do. So sort of a wishy-washy answer. So, great question. How can we ask employees for proof that they need to be out of work without risking HIPAA issues? The answer is, if you have an employee who is claiming that they're sick and needs to be out of work, they need to provide you with a MedCert. HIPAA does not prevent them from providing you with that MedCert, does not prevent you from asking for it. The only thing HIPAA might do is the employee may have to tell the doctor that, yes, I'm signing whatever doctor form to authorize the doctor to complete the MedCert. But as far as FMLA is concerned, HIPAA is not a bar. You do have to keep those MedCerts confidential, though. Let me remind you of that. Like, if you get a MedCert in, you have to keep it as confidential as possible. It's not something you talk about. Keep it separate from their personnel files in a locked cabinet. Can Connecticut FMLA and federal FMLA run concurrently? Could someone get more than the 12 weeks? They can run concurrently if the employee is eligible for both and the reason for leave applies to both. So, longtime employee worked for more than 12 months, more than 1250 hours, out for their own serious health condition, they're eligible for both Connecticut and federal FMLA. The leave will run concurrently. Employees only worked for you for 3 months, they're eligible for Connecticut FMLA, not eligible for federal, so they'll use up that Connecticut FMLA entitlement before they touch federal. So it really depends on the reason for leave and the eligibility. Reason for leave. You can take Connecticut FMLA to care for your sibling. You can't do that for federal FMLA. Question from someone from SHRM. Hello, it's always good to see you. Will AFLAC make a determination as to familial relationship? I think this goes to the affinity question. Yes, we will, the authority with AFLAC, in connection with the application for paid leave benefits. We're not involved in the decision the employer makes in connection with the application for FMLA. We will tell you what our decision is. So when an employee, as I mentioned, the employee has to tell their employer that they've applied to us. We will also tell the employer if we're approving benefits, letting them know kind of it's going to be a block leave from this date to that date. The hourly benefit's going to be equivalent to $13.50 an hour. So we'll give you that kind of information. Does the qualifying event have to happen in 2022? I have an employee who will be having a baby in December of 21. Will that leave qualify? Great question. We get a lot of these questions because obviously if you're pregnant, you know in advance it's coming most of the time. So an employee who has a baby in December of 2021 could receive Connecticut paid leave benefits for absences that, as long as the starting in January. So we would not pay for any absences in December, but they're still out with the baby. So it's still qualifying in January. So they could receive benefits in conjunction with any of those absences that are on or after January 1st. Can we use the federal FMLA form for CTFMLA requests? Yes, mostly. You just want to make sure. It's funny, I used to have the federal forms memorized, and now it's been a little while. You want to make sure, for example, the federal form relating to rights and responsibilities, you might need to tweak or add an extra piece of paper to. The MedCert, yeah, you're good. You could use the MedCert form. The military caregiver leave and qualifying exigency leave, absolutely, you could use those forms. In the situation where the employee is eligible for federal FMLA and Connecticut FMLA, would you recommend that the employer have the employee fill out the FMLA and Connecticut FMLA leave request paperwork and otherwise document that the leaves run concurrently? So, yeah, what I would say is most likely you don't need to have two separate forms, a Connecticut FMLA and a federal FMLA. You can have one form. As I said, you could use the federal form and just tweak it, or create a Connecticut FMLA form and use it for both. Or, as I said, DOL is going to be developing some forms too. So I would say have the employee fill out the one form. And then you will tell the employee, you're eligible for federal FMLA, you're eligible for Connecticut FMLA, you're eligible for Connecticut FMLA, but not federal FMLA. So use those forms to be able to convey that information, and then absolutely document that the leaves are running concurrently. We're in close communication with DOL, so we can actually try and follow up and see when they think their forms will be live, so that will make it a little bit easier for employers for planning purposes. One thing I should note, we do have our own forms for the medical certification, the caregiver leave. Those will be available online. If you want to use them, you can cut off the part that says CTPL Leave Authority and use them for yourself. That's fine. If, on the other hand, you have a form that you, like a MedCert, you want your employees to fill out, the employee could use that MedCert when they apply to us, as long as it's got the same information that we ask for. We're not going to be sort of really strict about saying, oh, well, this isn't the form with our name on it. You have to, fill out two separate forms. We want to make it as easy as possible. All right, it's 12:54 by my clock. Looks like we've answered all the Q&A questions. Just as a reminder, if you registered for this for this webinar by email, you will receive a follow-up email with the links, or you can go to ctpleave.org, click on the calendar of events, click on the day. We are offering something around the lines of like 30 webinars between now and the end of December. So pick the right day, and that way you can see the video for the day you went, and you can see the materials. And again, please check out ctpleave.org. We are updating the information on that website almost weekly. So just last week, we put out the information about preparing to submit claims, and we are putting up new toolkits and information. So, make us a favorite, visit us often, sign up for newsletters. I know that even though we don't have all the forms online yet, we are sharing some of those forms in the newsletter. So that's another great resource. All right, I'm not seeing any other questions. Really appreciate your time this morning and this afternoon, because it's almost 1 o'clock. And we hope that this was helpful, and check out ctpleave.org. Talk to you soon.
Thanks, Erin.